Thank you, Mr. Chairman. I appreciate the opportunity, and thank you for the witnesses for being with us this morning. I think this topic is incredibly important as stock trades made by members have come under incredible scrutiny over the past few years. When multiple senior members of Congress, and as my colleague Dr. Murphy mentioned, this is not a partisan issue, but when you have members of Congress that are consistently beating out some of the best investors in the country in the S&P 500, there's a problem. Upon my election to Congress, I actually divested all of my individual stocks. I think it is important to be as transparent as possible when working for your constituents and have no other allegiances. As was mentioned by my colleague from Texas, trust in this institution is low, and Congress can take action to restore trust. And I think this bill is a good first step towards regaining the trust that the institution deserves. But frankly, I don't think it goes far enough. I would also offer up that the rules on the books should actually be enforced, and members who improperly trade should not get a slap on the wrist. With that being said, I do want to hear from the witnesses this morning and talk a little bit about other alternatives. Let me offer this up. Many senior executives have to have pre-clearance trades before placing them to ensure they are in compliance with their employer's code of ethics and not trading non-public information. Because I don't own any individual stocks, I would wonder if this isn't an option. Would a pre-clearance process create transparency while still allowing members to lawfully purchase stocks to address some of the concerns? So, Mr. Copeland, if you want to, you were nodding your head feverishly. I think that.
Yeah, I think that's a reasonable approach in many cases here. I mean, this is exactly what happens in certain types of corporate situations, certain types of law firms, where you have to get pre-clearance with your internal people that work on the ethics and the compliance there. And I think something similar could be put into place. I would say easily. It's not easy, but it could be done in a way that's reasonably fair. Because even if you didn't require full divestiture, people will need to change positions. You may have companies that have spin-offs or mergers or other things, and you need to rebalance a portfolio. You're not working on inside information, but you need to make a move. I think pre-clearances there make sense, and it's sort of inherently showing that you're not trading on inside information in those cases.
Correct. Either one of you want to respond as well?
I think in principle that's an effective solution. We would want to look at any specific proposal for language on, again, how that is enforced and how that's addressed. But yeah, my father has worked in equities trading for banks for a number of years, and he has to pre-clear all of his trades as well, and occasionally he tells me about it and complains.
Well, let me also ask, do you think that we should focus on actions that legitimately restore the trust in government? We should, be focusing on actions that restore trust, not erode it. But I also think that maybe this isn't going far enough. I think about judges who oversee antitrust cases. I think about senior congressional staff who may actually have as much information, and in some cases more, than many of us do. I think about senior executive branch staffers who may have additional information. What would be one addition that you think could be added to the Stock Act that would make an impact?
In terms of who's covered, I tend to agree that at least for the non-constitutional officers, the other branches of government, you ought to have relatively comparable sorts of protections in there. And you're absolutely right. I mean, in the judiciary, it's totally the case. As someone who was a law clerk for a federal judge, is like, yeah, I knew things that were going on. I knew decisions that were going to be made. And we had ethics requirements over us. I don't know with specificity what they were. I never would have even, I couldn't have fathomed trying to trade on that information, but it's certainly a risk, and so it's something that I think ought to be swept in with the notion that you want to have some comity to the other branches, but I think if you're not talking about the constitutional officers, you could go pretty far.
Yeah, TBA has stopped short of endorsing similar legislation to apply to the judicial branch just because of the nature of lifetime appointments and some of the differences there. We have not come out in opposition to it either, but we would want to look far more deeply at including judicial branch members in these types of prohibitions.
Do you have Mr. Strauss? Okay. Well, I appreciate the conversation. I think this is an important one. I do believe that we have to do something to restore trust and faith in the institution as it relates to investments. And so I look forward to continuing this conversation. And with that, Chairman, I yield.